Hello, I'm Anthony Zoller, and this is the California Employment Law Report. In this video, I want to discuss a recent update on tip pooling on the federal level that's going to affect California employers in regards to whether they can share tips with back-of-the-house employees. On March 22nd, 2018, was part of the budget bill that President Trump signed into law, changed the FLSA and the federal law in regards to whether employers could require employees in a mandatory tip pool to share part of their tips with employees that do not have direct table service. Now, this is a new development in the law. Under the Obama administration, the DOL put out a regulation saying the employees could only share in tips if they had any direct table service. So this new law that's now effective as of March 22nd, 2018, does permit employers in California to share tips in a mandatory tip pooling arrangement with employees that do not have direct table service. So your back-of-the-house employees can participate in the tip pool. This is a big development for a lot of California employers because it enables the back of the house to share in oftentimes these very lucrative tips for the shift. So with this new development, what are some other issues that employers should keep in mind? Under California law, it's important to remember that the employee owns the tip. So the manager or owner of the restaurant can't take the tip, but mandated tip pooling arrangements are enforceable under California law as long as supervisors and managers don't participate in the tip pool. So as long as it's employees, and again, the back of the house can participate in this tip pool, but as long as employees who do not have a supervisory role in the company do not participate in the tip pool, that will be sufficient. That will be okay. Now, under a mandatory tip pooling arrangement, there has to be a reasonable relationship between the amount, the percentages being tipped out to other employees. Some examples of policies that have been upheld by governmental agencies or by courts include a policy in which 80% of the tips were allocated to the waiters and 15% of the tips were allocated to busboys and 5% of the tips were allocated to bartenders. Another policy that was approved was a policy that required cocktail servers to give 1% of their tips to bartenders. So it's important that employers get some feedback on their policies and make sure that their policies comport with these reasonable relationships that have been upheld by courts or by the government, by governmental agencies. And also, it's important that employers keep in mind that tips left for the employee does not change the employee's regular rate of pay. It doesn't have to be figured in when doing overtime calculations. And also, finally, and I'll leave the video on this point, it's important that employers review their local ordinances as well. So for example, Santa Monica's local ordinance requires that certain service charges collected by employers are distributed to employees. So it's important to keep an eye on the local level laws and definitely get some advice with this new changing and developing area of the law from a qualified employment lawyer if you have any questions about it at all. So with that, I'm going to wrap up the video. If you like the video, please like it here on YouTube. Post any comments or questions, and please subscribe to the channel as well. Thanks.